Hello, and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Geringer, and I'm the Extension Legal Specialist here in the Department of Ag and Resource Economics at the University of Maryland. And today we're going to talk about a recent Frederick County decision. It's really not Frederick County, it's a Court of Special Appeals decision involving a proposed solar development project in Frederick County, and how we work with vested rights and other things that could develop over time as we look at what happens once we go through the Public Service Commission's process and then, through the county process as well. So we'll talk a little bit about that and how all this sort of plays together. Folks that have listened to the podcast in the past may remember I talked about this with Washington County. There was a case there with perennial solar decision by the Court of Appeals, which held that the Public Service Commission statutory scheme in approving certificates of public convenience and necessity for a 20 megawatt or larger solar generating facility allows for the preemption of county zoning authority. Shortly before this decision, the General Assembly changed the certificate of public convenience and necessity process to require the Public Service Commission to give due consideration to the county's comprehensive plan and zoning ordinances. Just any county. So any county that has a comprehensive plan and zoning ordinances, this would have to be taken into account. Now, with this recent Court of Special Appeals decision, this involves a solar facility in Frederick County, and this demonstrates how this perennial and the due consideration requirement work together. So now we kind of have an idea of what this means. So as we go through the facts, we're going to see how the court has to handle changes to the law related to these solar energy development facilities in the state. Because of the mistakes made in the certificate of public convenience and necessity process, the Court of Special Appeals remanded to the Public Service Commission to consider remanded to the Public Service Commission to reconsider the approval considering based on the court's ruling. So let's give a little bit of background on this case. This decision involves the Public Service Commission approving of a certificate of public convenience and necessity for a 20 megawatt solar generating facility located on 170 acres of leased land in Frederick County and zoned for agricultural use. Frederick County had issued an executive order in early 2016, putting a 6-month hold on applications for special exceptions for anyone seeking to build a solar generation facility in the county, and stating clearly that any special exception granted, which did not have visible construction started, would be subject to the county zoning code changes, not gaining a special exemption. So after that order, Frederick County granted the special exception for this Lagore project, and in October 2016, Lagore applied for the CPCN process, that Certificate of Public Convenience and Necessity from the Public Service Commission. In March 2017, the Public Service Commission staff recommended granting the Lagore project this CPCN. Later that month, Frederick County introduced a bill that would create zoning requirements for solar facilities and would apply to those that had not obtained a Certificate of Public Convenience and Necessity, the CPCN. In May 2017, the dates really do matter in a lot of this. That's why I'm going through them. Lagore agreed to certain conditions on the proposed project before a public utility law judge as a part of this CPCN process, which Frederick County did not participate in. They were given the opportunity to, they did not participate in. A few days later, so they have this CPCN. Now, a few days later, Frederick County comes back and enacted the zoning changes for solar facilities effective July 2017. In early June of 2017, the county filed a copy of the zoning changes with the public utility law judge and moved to intervene in early July. A few days later, the public utility law judge allowed the county to intervene. So now we're at October 17th of 2017. A new state law goes into effect that now requires the Public Service Commission to give due consideration to county comprehensive plans and zoning ordinances. 2 days after that, the Public Utility Law Judge issued a proposed order approving Lagore's CPCN process. The PSC affirmed that proposed order in March of 2018. So what we see through this is, because of the legal changes that happened as we went through the process, as Lagore went through the process, this is probably may cause issues. It may not. I'd hate to give it away, but based on what I said earlier, you kind of have an idea what's going to happen. So we end up with an appeal before the Court of Special Appeals. On appeal, the Court of Special Appeals had to determine if Lagore had a vested right in the special exception. Prior to granting this exception, as we talked about earlier, Frederick County had issued an executive order relating to solar development requiring visible construction to have begun. Otherwise, any changes made to the county zoning ordinances would apply. To the court, this notified Lagore that the special exception was not a vested right, and proceeding with the project was at Lagore's own risk. Lagore had not started any construction before the county made the changes to the zoning requirements for solar facilities in July of 2017. Because Lagore had noticed that this special exception was not vested, the court did not see concerns that this violated Lagore's constitutional due process rights or fairness, since there was time to address the zoning changes in the proceedings. The next issue on appeal for the court to consider was whether the PSC, the Public Service Commission, had given due consideration to the new county zoning standards for utility scale development before issuing the CPCN process for Lagore's project. Now, in this previous decision that we talked about with Perennial, the Court of Appeals pointed out that the PSC has to give due consideration to a county's comprehensive plan, zoning, and other efforts related to the proposed project. While the PSC does have some discretion to preempt the county requirements, when looking at the zoning requirements impact on the proposed project, it first has to give that due consideration to those zoning requirements and the comprehensive plan in the county. The issue here was PSC never gave due consideration, at least to the Court of Appeal or Court of Special Appeals, to the county's zoning changes. The PSC argued that the county had waited too long till the record was closed to intervene in the proceedings. To the court, the PSC needed to go back and give some due consideration to those zoning changes on this proposed project. For these reasons, the court remanded the proceeding back to the PSC, allowing the PSC the ability to determine the weight to give to the county zoning changes and fix the issues related to the vested rights in the record. Because they had relied upon a vested rights in the record to do this, they needed to go back and cure that in the record because there were no vested rights. So why should we care about this? This case highlights the concerns for, ensuring that utility scale development of renewable energy fits within the county's comprehensive plan and zoning requirements, and at the same time meets the state's renewable energy needs. The legal changes in this case create confusion. We can go through the facts and sort of see it on both sides, I think. Some folks may come out more on Lagore's side. Some folks may come out more on the county. But there's a way to look at this. But because of that initial executive order from the county, Lagore never gained a vested right to the special exception. So because of that, that creates the problems later in the record that we have to look at. Even as counties in the state continue to struggle with what is allowed, the PSC still must give some due consideration to those comprehensive and plans and zoning ordinances in the counties. Simultaneously, Public Service Commission can preempt them related to these facilities, but it must be clear in the record when exercising this preemption power over the county zoning and planning ordinances and the comprehensive plan, after it gives due consideration. It has to explain why it's preempting based on this due consideration model. We're going to have to wait and see what the final outcome is on all of this. So if you have any questions on this, please email me at lgoerin@umd.edu, or you can tweet me at aglawpaul or send me a message on Instagram at the same handle. All this is in the show notes at the bottom. I put a link to this, to the post that accompanies this, and I'll put one in to a tab where you can see some more. This is all related to a USDA funded project that I have, so I'll put all that information in the show notes as well, so you can get more information on it if you want to learn about it. But for that, thank you for listening and enjoy the rest of your day.